Court of Appeal sitting in Abuja on Thursday affirmed Honorable Martin Amaewhule as the authentic Speaker of the Rivers State House of Assembly. The appellate court, in a unanimous decision by a three-member panel of justices, equally validated the Amaewhule-led members of the Assembly as bona fide lawmakers for the state. While dismissing an appeal that was lodged before it by Governor Similaye Fubara, the court upheld a judgment the Federal High Court delivered on January 22, which nullified the 2024 budget of Rivers State on the premise that it was not presented before members of the State Assembly that were known to the law. According to the appellate court, Fubara shot himself on the foot when he voluntarily withdrew a counter-affidavit he filed to challenge a legal action the Martin Amaewhule-led lawmakers instituted to be recognized as valid members of the Rivers State House of Assembly. The court held that Governor Fubara's decision to present the 2024 Rivers State Appropriation Bill to only 4 out of 31 members of the Assembly amounted to a gross violation of Section 91 of the 1999 Constitution as amended. It will be recalled that the Rivers State Assembly was factionalized owing to the frosty relationship between Governor Fubara and his predecessor and Minister of the Federal Capital Territory, Nyesom Wike. In the heat of the fracas, Governor Fubara sidelined the Amaewhule-led 26 members of the House that were loyal to Wike and presented the state's 800 billion naira budget, 2024 budget, before the 4 lawmakers led by Honorable Edison Ehe, who had emerged as a factional Speaker of the Assembly. The Ehe-led faction, which had also declared the seats of the Amaewhule-led lawmakers vacant for defecting to the All Progressive Congress from the People's Democratic Party, promptly passed the budget, which was quickly assented to by Governor Fubara. Meanwhile, following the intervention of President Bola Tinubu, both Fubara and Wike signed a peace pact that included the restoration of Amaewhule as the bona fide Speaker of the State Assembly. The factional Speaker, Ehe, who had approached the court and was joined as an interested party in the suit, subsequently withdrew all the processes he filed before the court and equally rescinded both his seat and his membership of the Assembly. Whereas Governor Fubara, in line with the terms of the peace deal, withdrew all the processes he filed to challenge the suit. However, the pro-Wike lawmakers only withdrew an impeachment notice they served on the governor while they declined to terminate their legal action. While deciding the suit, Justice James Omotosho of the High Court held that the budget was invalid as it was not properly presented before the Rivers State House of Assembly as required by the law. It held that Governor Fubara acted like a tyrant when he demolished the Rivers State Assembly complex and withheld funds standing to the credit of the Legislative House. The court also described as unconstitutional the redeployment of the clerk and deputy clerk of the Rivers State Assembly by Governor Fubara. Justice Omotosho stressed that the governor lacked the statutory rights to interfere with the operations of the Assembly, adding that he acted in contempt of a subsisting order that barred the parties from taking any steps to overreach the matter that was pending before the court. Besides, the court held that the National Assembly could not take over the legislative affairs of the state in the absence of the preconditions that were listed under Section 11 of the 1999 Constitution as amended. Consequently, the court, among other things, nullified all actions the Rivers Assembly took without the participation of the Amaewhule-led members of the House, among which included the presentation of the State Appropriation Bill. It issued an order of injunction restraining Governor Fubara from impeding or frustrating the operations of the Assembly under Amaewhule's leadership as his Speaker. It ordered the governor to release all funds standing to the credit of the Rivers State House of Assembly. While upholding the verdict of the lower court, the appellate court held that Fubara conceded to the Amaewhule-led lawmakers when he withdrew all the processes he filed against their suits. A party must be consistent in the presentation of its case. A party cannot approbate and reprobate or blow hot and cold at the same time, the appellate court held. Unanimously, all the 3 judges of the Court of Appeal agreed with Justice Omotosho's judgment, recognizing Martin Amaewhule as the authentic Speaker of the Rivers State House of Assembly. The court insisted that the appellant, Governor of Rivers State, treated the court order with disdain, adding that the quorum of the House of Assembly shall be 1/3 of its member and 4 out of 30 cannot form a quorum. The court said, democracy is anchored on the rule of law and not rule of might, as seen in the action of the Governor of Rivers State. And according to the judgment, all expenditure done by Rivers State's governor without the appropriation of Right Honorable Martin Amaewhule is illegal to the extent of its expenditures. By this judgment, all laws made by the Rivers State House of Assembly led by Martin Amaewhule, including the extension of tenure of the local government chairman, remains valid. It held that the orders of the trial court were appropriate given the circumstance of the case, saying the appeal Fubara filed before it amounted to an academic exercise. Accordingly, it ordered Fubara to pay a cost of 500,000 naira to each of the respondents in the appeal marked CA/ABJ/CV/133/2024. Let me start with you, Jamala.
Why are you starting?
So am I starting with you?
Yeah, just wondering why you.
I am really interested to know what you
what's
have
on my mind.
Yes, what's on your mind, Jamala? I mean, both you and Ndamzi have been regular on my show, particularly with respect to River State's issues when it has to do with legal tussle. I always love to hear you and Ndamzi, and I would want to start with you, Jamala. What do you make of this development?
My position is nothing strange to what the press release given by the Honorable Attorney General of Rivers State. I'm not holding brief for him, but I speak to my understanding of the law and as the facts unfold. Yes, your preamble stated it very well, or your excerpt stated very well, to the extent that, yes, there was an appeal, there was a proceeding that pended before my Lord Honorable Justice Omotosho in January. Another was given, a judgment was given to the effect, as you have so far stated. I will not want to go into the legalese of why should the defendant, governor's lawyer, withdraw their own processes when the person who brought them to court, the Amaewhule, have not done so. Because it is a procedural somersault for the defendant to have withdrawn his process. The processes you filed challenging the allegations leveled against you. Those allegations are still existing, but you have withdrawn in other words, admitting. It was a landmine prepared for them, and they unknowingly, going to the directive of Mr. President, fell into it. But that is for another day. Let's look at the judgment as came yesterday. With all due respect to my Lord, the Honorable Justices of the Court of Appeal, that is their position, is not final. Remember, there is right of appeal to the Supreme Court. But assuming that the Court of Appeal decision yesterday is to stand as a final judgment, what is the effect after the defection of the lawmakers? This judgment was instituted prior to the defection of the lawmakers. These proceedings was instituted by Amaewhule prior to the defection of the lawmakers, when the Amaewhule-led assembly somehow sensed that the governor was about neglecting their role. And so they approached the court to determine whether the governor, by provisions of some of the constitutions, is not mandated to relate with them as the legislative arm of the assembly.
And you said at that time they've not defected.
As at that time, yes, they have not defected. As at the time they instituted this action, they have not defected. They only defected earlier this year. Yeah, I stand to be corrected. You have the records if you do so.
Earlier this year?
Yes. December. Okay, December, right? Now, this suit was instituted sometimes around October, November, and judgment given in January.
So how come the judgment included legitimizing them?
It did not legitimate. No, it did. The judgment,
as the authentic speaker.
No,
of
the judgment did not determine the question as to defection, whether their defection was right or not. You remember? it only talks about, in the eyes of the law, looking at the assembly members, whether they are members of the assembly and the governor is bound by law to relate with them. It has nothing to do with defection. The issue as to how Edison came up, the Edison and Jumbo came up, was upon the declaration of a court order, ex parte, directing them, recognizing them as the authentic House of Assembly members in Rivers State, prohibiting some set of persons from functioning. That was when the budget of 2024 was presented to. So there are two different games. Yes, there are two different games playing out. Yes, the judgment of the Court of Appeal yesterday stands with law. Because in law, when there are no controverting evidence, when there are evidence placed by party A is not controverted by party B, the court is bound to accept those arguments. Unless there are, it is obvious to the court there are some certain things that is against the principles, maybe party A wants to misdirect the mind of the court over an existing known issues of law. Then the court can direct its mind, but the court is bound. The Evidence Act is that there are plenary of authorities to that effect. So yes, it is true. The governor and the team of the governor shot themselves in the foot when they withdrew those applications. That's right. But to what extent is the judgment? Because I am of a view that is also an academic exercise. By the governor? No. The judgment as of yesterday,
by the appeal court was a mere academic exercise.
The judgment is specifically with reference to the appropriation law.
Why do you say it's a mere academic exercise?
This is November. This is October. Appropriation law is meant to serve till December, and if for some certain reasons, the assembly, the governor is not able to make another budget passed by the assembly, extended up to a period of 6 months. Now, some of those expenditures has been carried out. Salaries have been paid to workers out of it. Projects have been executed out of it. Declarative reliefs to undo an act that has been done is an academic exercise.
All right. Do you recall when the budget was presented to Edison here?
Yes, I do.
What month was that?
That was late December.
December.
Late December, yes.
And
December.
January.
Yes.
Because it's a full cycle budget.
Yes.
Now, January 22nd, there was a judgment.
Yes.
And in that judgment, the governor was ordered to represent...
That was not a final decision.
Hold on.
Okay.
The governor was ordered by Justice Omotosho to represent the budget. First of all, the judge nullified the presentation of the 2024 appropriation bill to Edison Ehe, led House of Assembly, and the judge ordered the governor to represent the budget to Martin Amaewhule, led House of Assembly. If I may ask, did the governor appeal that matter?
That is the judgment that came up yesterday.
Hold on. There was a judgment in January.
Yes, Omotosho's judgment.
That judgment, part of that judgment, because a lot of things were, a lot of prayers were granted.
Yes.
Part of the prayers that was granted in that judgment was ordering the governor to represent the budget. Now, you are saying that it's a mere academic exercise. I mean, the judgment yesterday was a mere academic exercise because the lifespan of that budget is almost expended.
Yes.
However, I'm bringing you back to January.
Yes.
That
when the judgment was given.
Yes.
Can I answer that?
Hold on. That when the lifespan of this budget barely started, that a judge gave a judgment and ordered the governor to represent the appropriation bill. So do you call that also an academic exercise?
I'm coming. When a judgment is given and you are appealing against that judgment,
did the governor appeal it?
That is the judgment that came. It is that appeal. Yes, this appeal for judgment of yesterday.
When was it appealed?
I wouldn't know when they filed, but the judgment came up yesterday. That is the judgment of Omotosho.
Now the question is,
let me
when was it appealed?
It was appealed within the time allowed by law by a party to appeal. That was why the judgment came yesterday. Now, I'm saying that when a judgment is given, and it's against you, are dissatisfied with that judgment, and you appeal, and you have also made the necessary processes in staying those execution, and you are allowed to. Shoma, if you go ahead acting as though that judgment never existed, it can never be reckoned against you in the eyes of the law.
Did the governor get a stay of execution of that
whether
judgment?
Whether the government, I cannot.
I am clarifying you on that.
You and I can't say so.
I can't say so. I can say so because I do my investigation. There was no stay. No. There was no stay of execution of that judgment. The second question I want to ask you, Barrister Jamala.
Are you imposing it on me?
No, you're saying you don't know, and I'm clarifying you. You're telling me I cannot say so. I can say so because I'm telling you a statement of facts.
Supposing I bring a superior argument as to the fact that
you have to bring evidence. Yes. But you just said now, yes. Barrister Jamala.
I don't want to be
I am using your word. I am using your word.
Yes, I said I don't know to the extent that I do not have that valid application.
Well, I am telling you. Okay. Now, secondly, Barrister Jamala, the governor appealed the judgment of Justice Omotosho.
Yes.
Very quickly, before I come to Ndamze, the governor appealed the judgment of Justice Omotosho. Now, the question would be, the governor or the government of Rivers State in the first instance withdrew their defense or their application, whatever legal
counter affidavit,
okay, good.
Address in
now
position,
by that
papers.
particular action, they have completely removed themselves from that matter, and in face of lack of defense or any counter applications,
yes.
the judge gave a judgment. If the governor and the government of Rivers State have removed themselves from a matter, which means they are not party to that case, what is the locus? What is the locus to appeal? I'm just asking. Yes, probably in this instance, I'm not that much learned.
Okay, so let me educate you on that. Please. And see, they are parties to the suits.
Okay.
But they only withdrew acting in good faith per the directive of Mr. President.
Sentiments aside, according to the law.
I'm coming. I'm calm. There is no sentiment. I speak law.
All right.
Now, acting in good faith, per the directive of Mr. President, parties go and withdraw every application you have pending in court. All right. The side of the governor went and withdrew the application. It is not a defense in this circumstance. The directive of Mr. President, get me right, asking that they should go withdraw their processes. It's not a defense here. My only query is to the legal team who withdrew their own processes ahead of the plaintiffs.
All right.
That aside, the judgment that although they have withdrawn their processes, a party at any point in time, even at the court of appeal, has the right to raise issues of jurisdiction. Although you have withdrawn your processes at the lower court and judgment is given, you can challenge the jurisdiction of the court, even up to the Supreme Court. So if that was never presented before the court of appeal, you are even placing me on a position to give the legal team freely pro bono advice. They can challenge the jurisdiction of court. Budget is a state law. And it is not the federal government, it is not the federal high court that has jurisdiction to determine on state laws. It is the state high court. And so for every action, there are the suit brought before Amaewhule Omotosho muzzled so many state issues and national issues. Issues that have to do with the National Assembly, Section 92, giving Section 92 and 91, giving jurisdiction to the Federal High Court.
Jamala, you're pushing me back to remind you of something you said that is contradicting your statement now with regards to jurisdiction. Because now I'm beginning to wonder. I'm beginning to hold on, Jamala. I'm beginning to wonder. I will tell you. Because I'm beginning to wonder if the law is subject to interpretation depending on your mood. Now, you recall. Jamala, you recall that when we were having conversation around the issue of RISEC and the litigation, right? And APP went to court with respect to RISEC, the elections. And the State High Court now gave RISEC instruction to go ahead with a document belonging to a federal institution, and the State High Court as well ordered a federal institution to participate in the election. And you were of the opinion that the State High Court had jurisdiction to give that order because the matter was state related.
Has this changed in the circumstance?
But then
that opinion
it still boils down to jurisdiction of the federal and the state.
I'm coming as my jurisdictional explanation with respect to this circumstance changed from my previous.
It has changed to a
it
large
hasn't,
extent.
maybe it's your understanding. It hasn't. I said the state high court has the jurisdiction to interfere with national institutions so far as it relates with the activities of the state.
So why can't the federal interfere with the state institution as long as it relates to the matter of the State House of Assembly that the state does not have jurisdiction to entertain? We'll still come back to that. But
Section 251 is so clear about jurisdictions of court.
All right.
The federal high court cannot determine on River State-owned law.
But River State can give order to a federal institution.
So long as it relates with the activities of that state.
And in this instance, the River State House of Assembly and the Appropriation Bill is not directly related to the River State House of Assembly.
River State House of Assembly alone is not. Is River State House of Assembly?
So are you telling me in this instance that a state high court can interfere in the matters of the State House of Assembly because of the budget?
A state high court can question the procedure of lawmaking. The National Assembly, the federal high court can question the National Assembly with respect to their procedures, but it cannot interfere in how they go about.
Now,
but if the procedures is unknown to law, the court has a way, the court has the jurisdiction to direct its affairs.
In this instance, the Appropriation Bill and the procedures has to do with the State House of Assembly.
River State House of Assembly.
Which the State High Court does not have jurisdiction.
The State High Court has the jurisdiction.
Matters pertaining to State Houses of Assembly.
No.
All right. We'll come to that.
Yeah, you're making it. Yeah,
no, I'm not. It's simple.
When River State laws, let me answer you. River State laws, as emanating from River State House of Assembly, it is the River State High Court that has the jurisdiction to interpret it.
Oh, hold on. I ask a simple question. Can the State House of Assembly entertain matters pertaining to, let me remove River State. Can state high courts entertain matters pertaining to state houses of assembly?
Very well.
They have the jurisdiction.
Very well. They have the jurisdiction.
All right.
Yes. Very well.
All right. That's all I want to hear.
Thank you.
Now, Ndamzi, what do you make of this story?
Yes, thank you very much, I have listened keenly to my good friend and brother, Barrister Jamala, and I want to state emphatically that the Court of Appeal only re-echoed the position of the Constitution in giving that judgment because, one, it is right that when a party to a suit withdraws his or her matter as the matter is ongoing in court, you are invariably telling the court that admit to all allegations and facts before the court. So just like he mentioned that the governor's team shot themselves in the foot, and the Court of Appeal went ahead to re-echo it that it is irredeemable, even up to the point of Supreme Court. He knows he's a lawyer, having withdrew that matter doesn't have life again, because the governor's team have inadvertently admitted all facts pleaded by the applicant at that stage. So that is that. Then on whether the Federal High Court originally should have assumed jurisdiction, the answer is yes. Because at the commencement of that trial, you can see parties to the suit. The National Assembly was a party. The police was a party. Rivers State government was a party in that suit. And if we borrow a leaf from the previous Court of Appeal judgment of the 27 House of Assembly members and Rivers State, the court assumed jurisdiction in that matter and went ahead to say that since it has to do with houses of assembly, that Federal High Court was right in assuming jurisdiction. So at this point, I do not, in my own view, I do not believe that it is a jurisdictional concern. It is no more a jurisdictional concern, but a pure legal concern. Legal concern in the sense that Professor Wyndham Holmes made it clear in his position that there is nothing more pretentious other than what the court says is the law. the Court of Appeal in their wisdom have looked at the various provisions of the law, and came up with a judgment. Let's look at Section 96 as it were. It's very clear. The section talks about quorum of the House of Assembly. The court have also re-echoed that position that there is no way a 4-member assembly can transact legislatively for the entire River State. And I think it's, in my own view as a lawyer, I think it is reasonable to have held same. Because River State has 32 House of Assembly constituencies, and one has passed, remaining 31 before the crisis ensued. Now, even before the presentation of the budget by the governor to Edison Ehe-led assembly, the order of Justice Omotosho had come. The order was very direct. Represent this budget to the assembly, Martin's Amaewhule-led assembly. The governor flagrantly disregarded the court order. And in that, I remember in that judgment also, the court recognized the speakership of Martin's Amaewhule and the membership of other disputed assembly members. The court also, in its wisdom, went ahead and ordered that the governor shouldn't interfere with the legislative business of the House. The court went ahead also in criticizing the governor the governor transferring out of the assembly the clerk and the deputy clerk, because that is within the purview of the assembly. The governor has no right to interfere in legislative matters. So the Justice Omotosho Court haven't made these decisions. What the Court of Appeal only did was to uphold everything Omotosho said in its entirety. And I know my good friend Jamala will talk about what would have been the position of the law if in the event where, let's assume, Martins and Co. actually defected. You know, I remember one of the time I had an outing with him on the radio station. This was his position. And in that outing, I was very clear. I told the listening audience then that there is no way 4 House of Assembly members can embark on legislative transactions involving the entire state. Okay? Then now, if you look at Section 96, sub 2 of the Constitution, it is very clear that in the event where quorum is lacking, the Speaker should adjourn the House indefinitely until whatever be the reason for quorum lacking is resolved. So, ordinarily, let's assume Martins and Co. actually defected, which the court have not said that they did. Never a time would the governor think that he would present a budget meant for expenditure of the entire state to 4 members of assembly. It is not lawful, and I thank God that the Court of Appeal have, dismissed that position and upheld the judgment of Justice Omotosho.
So can I
hold on, Jamala. Now, I want to ask you a question, Damzi, with regards to the governor appealing this matter. The question I want to ask, like I asked Jamala, I'm still going to throw the same question to you. What does the governor have the locus to appeal that matter? Because let me break it down to my own layman understanding. Now, you have a case with someone, and you took the matter, or both of us have a case before the court. You took the matter to court, and I'm the respondent. And after a while, for whatever reason, I withdraw my own proceedings from court and show disinterest and never came to court again, and judgment was passed. By the reason of my withdrawal from that matter and removing myself from that matter and not raising any defense whatsoever. Now, is that not me abdicating, or is that not me waiving my rights? Is that not me within my rights?
Thank you.
If that is so, and the judge and the court gives judgment at the end of the day that does not favor me, do I have the right to start crying foul and probably run to a higher court to tell them to come and adjudicate on this matter that the lower court has dealt wrongly with me, when of a truth, when you look at the court proceedings, I waived my rights? So that's the question I'm asking. Does the governor or the Rivers State government in this instance have the locus to appeal the judgment of Justice Omotosho?
Thank you very much, Emma. You can see even the Court of Appeal in their wisdom re-echoed it. And I'm going to say it again. It is right in law that you cannot reprobate and at the same time approbate. That matter died a natural death when the legal team of the governor withdrew the matter from the court. I say this and I stand to be corrected in any forum. Even the court have, posited that what the action of the governor is unknown to the law. Having withdrawn that matter from the Federal High Court, you are inadvertently telling the court that I have admitted all facts pleaded by the applicant. I am also withdrawing my allegations. Don't forget that the counter affidavit deposed by the governor's team, okay, contained allegations against Martins and co. So the governor's team haven't withdrew that allegation. Simply means you are telling the court, I am withdrawing my allegation, and everything the applicant said in his own affidavit is true. So inadvertently, the governor's team admitted all facts pleaded in the affidavit deposed by Martins and the 26 remaining House of Assembly members. So at this point, running to the Court of Appeal, when you willfully withdraw your matter, what do you expect the court to do for you? That is the question. That is the reason the court said that their action is completely unknown to the law. So, and I'm very, very confident that the Supreme Court will re-echo some same position.
Right.
Then also, before you ask another question or go to my friend Jamala,
all right,
I would want to say something. We shouldn't forget that the Federal High Court, led by the Federal High Court of Justice James Omotosho, was very emphatic in his judgment that Martin's speakership was never in contention. Okay? And now, Court of Appeal have come to say we are upholding everything Omotosho held in his judgment. So, in the eyes of the law, Martins remained the authentic Speaker of the Rivers State House of Assembly, and the 27 others, in conjunction with Okojombo and others, are all valid members of the House of Assembly. So I will use this opportunity to advise the governor to appreciate that fact, allow this matter die a natural death.
All right.
Carry everybody along in the interest of peace in this state.
All right, we'll still come to that in our second story, so let's not preempt that. But the question I wanted to ask was a concern raised by Barrister Jamala. And I am asking you that question. Barrister Jamala said that Justice Omotosho, or Federal High Court in this instance, didn't have the jurisdiction. He questioned the jurisdiction of the Federal High Court to entertain matters relating to the 2024 Rivers State budget. Now, his argument is premised on the fact that it is a state document. So now, if I may ask you, Ndamzi, can you throw more light on that?
Yes, on jurisdiction.
Yes.
Fine.
With regards to the circumstances of this matter, because I know that every matter is peculiar. The circumstances of the matter that was brought before Justice Omotosho in relation to the presentation of the 2024 appropriation bill by the governor to Edison Ehe-led faction of Rivers State House of Assembly as at that time. So I would want you to marry all the intricacies together and determine whether, according to the law, the Federal High Court in this instance had jurisdiction to entertain that matter.
Thank you very much. I want to state categorically, for the interest of the listening audience, and also to clarify this issue of jurisdiction as regards this matter. Do not forget, the dispute as have arisen wasn't just budget 2024 alone. There were already disputes before the issue of budget emanated. And the dispute began with the suspension of Edison and Co. by the Rivers State House of Assembly. That suspension was never lifted. That is the genesis of the crisis. Then the second phase of the crisis heated up when the governor made moves to remove Martins through the instrumentality of Edison and Co. That was when the crisis became very imminent in the House. Then now, before a lawyer files action in court, the first thing that comes to mind is the court I'm approaching. Does this court actually have the jurisdiction to hear this matter? Secondly, the parties to the suit. Who are the parties to the suit? Then thirdly, you not look at the general ingredients as pertaining the dispute or the cause of action. Then now, in the case of the House of Assembly, do not forget that the Rivers State governor, when the crisis was heightened, Rivers State intended to renovate the building. They went ahead destroying the building and all that. When Martins and Co. filed to the Federal High Court, to maintain law and order, don't forget a federal agency must come in, which is the Nigerian police. Then at that point, there were rumors of National Assembly taking over the functions of the State House of Assembly as enshrined in Section 11 of the Constitution. So at that point, the National Assembly, which is a federal lawmaking entity, comes in. So there is no way any right-thinking lawyer would have filed in the High Court, considering that there are federal agencies involved and there is a federal entity also, Federal Legislative House is involved here. So parties must consider the Federal High Court as the court that has proper jurisdiction. That is why in the last judgment of the Court of Appeal before this one, the court was very clear and said Federal High Court had jurisdiction. So if it were to just be disputes surrounding budgetary concerns alone, we'll be looking at the proprietary or otherwise, or whether or not the State High Court had jurisdiction. But in this case had babies, branches that led to other federal concerns. So no way the State High Court would have had jurisdiction.
And that issue cannot be treated in isolation.
The High Court, that issue cannot be treated in isolation.
Okay. Now, Jamala, what do you have to say? You've been itching to say something.
I admire this being evasive of the direct response. You asked him a very specific, direct, unambiguous question, which is to the fact that does the Federal High Court has jurisdiction to adjudicate over state laws.
And I also narrowed. Hold on. Yeah. I also narrowed it down. I said considering. No, hold on. Let me still say what I said. I said, and I'm putting myself. You can still replay the video. I said I am aware that every case is peculiar, and I said considering the peculiarity of the matter brought before Justice Omotosho, right, and the fact that the governor had presented the budget to Edisnehi-led faction of Rivers State House of Assembly, and now Justice Omotosho is giving this order. Now, considering the budgets, and how it's linked to the State House of Assembly, does the Federal High Court have jurisdiction to entertain that matter?
There is nothing different from what I was even asking.
Which I'm asking, can it be treated in isolation?
It can be treated, cause of parties cannot give jurisdiction to a court. Parties, cause of action, severance of cause of action. Parties cannot, by their action, donate jurisdiction to a court. Yes, he talked about, if you're talking about parties, because there are national institutions that are attached to the suit, making them parties alone, give them the court, clothes the court with jurisdiction.
To entertain that
To
matter.
entertain the matter with all sense of responsibility. I differ in that line of thoughts.
All right.
It is the states. Yes, the issues that has to do with state government relating with the House of Assembly. Section 92 is clear. 92, 91 is clear. Donating powers to the Federal High Court. It's very specific. And so a state cannot, state has High Court cannot do so.
Cannot do what exactly?
Cannot legislate the issue of whether there is a seat is vacant in the State House of Assembly. So when the judgment of, the expert...
You're limiting it. Is it that the State High Court cannot...
You
said with regards to
all
the
causes of actions. Let's severe all the issues.
Okay.
There are issues that the Federal High Court is clothed with the jurisdiction to entertain.
Okay.
I agree. But the ones that the Federal High Court is not clothed with the jurisdiction, you cannot say those reliefs are ancillary.
All right.
That because I am clothed with the relief to do this, I'm clothed with the jurisdiction
I'm
to
joining
entertain
this one
also,
into it.
and joining this one, that I do not have the jurisdiction to do so. That is not the law.
All right.
That is my point. He can go ahead if Omotosho ordinarily can determine whether the state government can relate with Amaewhule-led assembly, having been constituted, nothing is challenging.
He has the jurisdiction to legislate on that.
It is the powers of the it is the powers of the Federal High Court to do so.
Okay, to tell the governor to relate with so and so House of Assembly.
So, yes.
Okay, all right.
It is his powers to do so, but it's not his powers to determine whether the budget of a state is properly presented or not. It is not the powers to legislate whether the budget of a state is properly passed or not.
That is
the responsibility of a state high court.
Now, this is the issue now, Jamala.
I beg to differ.
All right. All right.
Yes, I beg to differ because I think we are missing out a point here.
And that is?
The course of action was not premised on whether the budget was properly passed or not. The course of action was basically on whom the budget was presented to, the rightful speaker. Okay? And I and you know that when it comes to disputes on speakership of a House of Assembly in Nigeria, Federal High Court is saddled with that responsibility.
I agree, but
no, I want to clarify a position you just took.
Yes.
Okay? You said here that the State High Court had jurisdiction when it has to do basically on budget. But state laws.
Yes.
But
budget
we should
state law.
Yes, but we should clarify it properly for the interest of our viewers. The dispute, the course of action has arose then was not whether the budget was properly passed or not.
So if that was
the
course of action was just simply whom was the budget presented to.
Yes.
Don't forget it has to do with the Speaker of the Rivers State House of Assembly.
Yes, if a
and
court,
the Speaker has the jurisdiction.
You answer the very
The course of Federal High Court has jurisdiction when it has to do with
if the Federal High Court lacks the jurisdiction to entertain state law, why would the federal government, Federal High Court, has jurisdiction to abolish that same law that it lacks jurisdiction to entertain?
But no, we should not mislead the viewers.
We're not. No, we are reasoning jurisprudentially.
We should not mislead the viewers. We should not also digress. We should not also digress.
It's a very simple.
Here, I want to reiterate again.
Yes.
The position is very clear. The course of action as arose in the House of Assembly. In fact, the course of action has to do with the budget it's not whether or not the budget was passed properly. If that had been the question, State High Court will have the proper jurisdiction. There won't be need for parties to run to Federal High Court.
Parties with strange motive,
yes,
will do.
But the onus here was basically on whom was the budget presented to. The budget was presented to a speaker that was never existed. One, the budget was presented to a quorum that was never formed. Two,
that is your own understanding.
Who do you think will have the jurisdiction? The Federal High Court.
Well, that is your own understanding. I agree. Like when you talk about, I don't want us to take us back to 2023. Now, I have held the position in the morning, and I said the judgment of yesterday, to a relative extent, is a mere academic exercise. And I will give you the reasons. The legality, the status of this 27.
All right, I think since you're going to the status, because I think that's where our conversation is going to, which is the exact second story. So let me just take the second story, and then Jamala, you continue with your trend of thought. Fair enough, right? All right.
Fair enough for once.
All right.